Being here, this is a big day for us, and we're really excited to announce the fact that the PolyMet permits have been struck down.
Hello, I'm Paula Maccabee. I'm the Advocacy Director and Counsel for WaterLegacy. And I've been so busy this morning, wrote nothing. So I'm just going to tell you what I really think. This decision is an amazing win for Minnesota. And it's an amazing win for more than 100,000 Minnesotans who submitted comments critical of this project, either during environmental review or during the DNR permitting process. Because what Minnesotans all over the state, north, south, Twin Cities, everywhere, were saying is this project is too risky, the pollution is too toxic, it will not only hurt our fish and our wild rice, but the developing brains of infants and fetuses and children. And they were saying that this project is a climate change disaster because of the amount of fossil fuel in processing the ore and blasting it out of the ground, and because of the destruction of more than 900 acres of wetlands. And finally, that this project is an environmental justice catastrophe because the impacts on the downstream communities particularly affect indigenous communities, communities of color, low-income people who depend on fish and wild rice for sustenance. And so what the Court of Appeals did, which is so monumental, is they said we're going to follow the rule of law and let the important decisions about sulfide mining be made in front of an objective administrative law judge with members of the public and experts able to bring information forward all in the light of day. So what the Court of Appeals has done is let the sunshine in so that the difficult decisions that Minnesota has to make about sulfide mining can be made under impartial, open scrutiny. Now I'm going to give you a little highlights about the court's opinion, and then I don't think Aaron mentioned it, but after we're all done talking, you can ask questions of all of us. Basically what the court said is the critical issue here is that a contested case is needed. And the court said that a contested case is something that is required that the DNR do under law. It's not a matter of unbridled discretion when there are facts in dispute and credible probative evidence. And the Court of Appeals said that some of the issues that everybody in this room has been concerned about and all of our partners up here have been concerned about really need to be evaluated in a contested case. Is the tailings dam upstream style construction too risky? Is the tailings storage, wet closure, without dry stacking, without a liner, is that too dangerous? Is the financial assurance inadequate to protect Minnesota taxpayers? And has Minnesota really thought through the consequences of having Glencore, an international bad actor, actually in charge of the PolyMet project when the permits don't even hold Glencore accountable? So that's kind of what the Court of Appeals said, this is what we have to look at. This is what DNR is supposed to look at in the contested case. And also very interestingly, Ms. Hoffman mentioned the idea of perpetual treatment. The Court of Appeals made one decision on the basis of law, and that's that permits to mine have to have a term limit. And what that means is not just that the number of years that the company is going to mine has a limit, but looking at closure, post-closure, post-closure maintenance. So this is an opportunity for us also to ask the question that so many Minnesotans are asking, which is the short-term profit worth it for potentially perpetual pollution of Minnesota waters in the Lake Superior Basin? So that's a thumbnail sketch. Feel free to stay, ask questions, and we all appreciate you coming here on such short notice. Thanks so much. I think the thing that you can do to help is to keep doing what you're doing. Because I think part of what has made the PolyMet project different from other permitting processes is not just the deference that is lessened because of the seriousness of environmental issues, but because there were so many people who've participated in some way in the process, whether it's showing up at hearings, or whether it's sending petitions, or whether it's coming in and talking to your legislator, or whether it's putting those beautiful Stop PolyMet Protect Water lights. So that I think that really, if we want to continue to say this is an important issue, the public and the customers, you're supposed to listen to us at least as much and really according to law first. Then one of the things that everybody can do is keep doing what you're doing. I mean, support us because our lives are really kind of challenging right now, but more importantly, get your voice out into that public space. When everybody in this community, when Star Tribune writes an article, when MinPost writes an article, comment, respond, send your own letters to the editor, talk to your neighbors, because I think judges are just people. And they're going to be listening to what is happening in the community. Does the community think it's a done deal and we really shouldn't pay attention? Or is the community saying, I want the science, I want the law, I want a fair process? And if you're all yelling, somebody's going to listen.